In this video, I'm going to be talking about dealing methamphetamine in Indiana and what to do if you've been charged with this offense. Dealing meth is a serious offense in Indiana, but it's also an offense that's easily charged. And in fact, there's a lot of instances where there's somebody who's just considered a drug user, not a dealer, but they're charged with dealing based on the inferences surrounding the circumstances. We're going to be talking about that today and what you can do in those kinds of cases. So about me, my name's Nathan Vining. I'm a criminal defense attorney here in Indiana, and I represent individuals in criminal defense cases throughout the state of Indiana. By the end of this video, you should know a lot more about dealing methamphetamine in Indiana and what to do if you're facing that kind of case. So one of the first things you do in any criminal case is look at the statute. Indiana Code 35-48-4-1.1 outlines the laws on dealing methamphetamine in Indiana. And what it says is a person who knowingly or unintentionally delivers or finances the delivery of methamphetamine, pure or adulterated, or possesses with the intent to deliver or finance the delivery of methamphetamine, pure or adulterated, commits dealing methamphetamine. The offense alone, at its most minimum, is a level 5 felony. It's also important to know that there's an intent element with the statute. It's knowingly or unintentionally. So you have to knowingly or intentionally be dealing. The statute, like a lot of the drug statutes in Indiana, increases the penalty for the amount of drug that's being dealt. So here it's a level 5 if you're dealing under 1 gram of meth. It goes all the way up to a level 2 if you're dealing over 10 grams of meth. There are also what's known as enhancing circumstances. So those are circumstances that they're different things that are set out. It's, for instance, committing the offense in the possession of a firearm, committing the offense around children, committing the offense on school grounds. So as you can see, there's a few different circumstances where your penalty could be enhanced based on the conduct and where the conduct occurred. The penalties for dealing methamphetamine can also be serious. At the low end, it's a level 5, which is 1 to 6 years imprisonment. It goes all the way up to a level 2, which is 10 to 30 years imprisonment. So if you're facing a level 2 meth dealing charge, there's a lot of risk and there's a lot at stake because you could be facing a very severe penalty. So if you're facing a drug case, there's a few things that you're going to want to take a look at yourself to see what's going on. And one of the first things is the charging information. This is a document that lays out the statutes that you're charged under. So you can look at this and see if you're being charged just based on the quantity of the drug, or if you're being charged based on the quantity of the drug and an enhancing circumstance, and even see what enhancing circumstance is being alleged. The second thing you're going to want to look at is the probable cause affidavit. This is a summary by the police officer or the prosecutor that outlines what they're saying happened, and it gives you an overview of the type of evidence that they're going to be using against you. And the third thing, you're not going to have this at the outside of the case, but you're going to want to see the discovery, and that's the evidence that the state has against you. You're going to want to get all of those documents and review exactly what you're facing and what they're saying happened and what evidence they have. So what you can see here is an example of a charging information. Here you can see the state is charging count 1, dealing in methamphetamine with an enhancing circumstance as a level 2 felony. It shows the statutes that are being charged, and it gives a summary of what they're trying to prove. So you can see here the state is alleging that this individual on a certain date did knowingly or unintentionally possess with the intent to deliver methamphetamine between the weight of 5 and 10 grams in the presence of a child. And they're saying that's contrary to the form of the statutes and against the peace and dignity of the state of Indiana. So this is what a charging information looks like. So if you're facing a meth case, you're going to want to take a look at the charging information to see what statute you're being charged under and whether or not there's been any enhancing circumstances being alleged. So the next thing we're going to talk about is defending a meth dealing case. What do you do if you're being charged with this case, and what are some common defenses that I would see typically as a defense attorney, or what I would be looking at or looking for if I was looking at your case? One of the first things when you're defending a drug case is that a lot of times dealing is charged based on an inference. What this means is that the person's not actually caught delivering drugs. A lot of times it's the state or the officers are looking at the circumstances surrounding the possession and saying that they believe this person is dealing and is charging it as such. So what they look at in this kind of case is the amount of drugs. If you're, for instance, you're caught with a lot of drugs, they look at how it's packaged. So if it's packaged in a lot of different baggies, typically an indication that a person may be dealing. They look at whether or not there's cash, guns, or even multiple cell phones. So what they would do is take evidence around the drugs that they found and see if they can find different ways to charge dealing based on the circumstances. So they would look at all these different things, and then they're saying, this person had a gun, they had a lot of cell phones and cash, and they had all these different baggies with a lot of drugs in them. They could then, based on inference, charge you with dealing. So it's important to know that's how a lot of times dealing is charged in the state of Indiana. It's not actually with a person caught dealing, it's charged based on inference. And there's a lot of different things you can do in a defense of that case, because you may want to argue that this is just more of a possession case and the person was a user and not a dealing. And you could make that argument based on the intent required, because to show dealing, you have to prove that they're knowingly and intentionally dealing. And a lot of times there is an argument to be made that it was just more of a possession and the person's a user and not a dealer. So I'd look in those instances to see if maybe there was a real reason to have that cash. So a lot of times you could track the person's pay and show that the person, maybe they are paid cash weekly and they just picked up cash from work that day. So if you're dealing with a meth case based on inference, it's really a fact-sensitive case and you're going to want to talk to an attorney about it. You also see 3 other common fact patterns that are related to a drug dealing case. The first is what's known as a Terry stop. And this is the kind of thing where a person is walking down the street and they're stopped by an officer, and then ultimately that stop leads to a search, and then that the person's found with drugs on them and the officer believes that dealing is going on. So if you're dealing with a Terry stop, one of the first things you want to do is think, can you challenge a stop? You're going to look at what led to the search. Did the officer have reasonable suspicion to stop you? And then you're also going to want to look at how is the dealing inferred. So you're going to want to look at those fact patterns to see whether or not it's dealing or if it's possession. The second common fact pattern are traffic stops. A lot of times you see a person that's been stopped and there's drugs discovered, and then ultimately they're charged with dealing. So if you're seeing a traffic stop, one of the first things you want to do is see if you can challenge a stop. So you're going to want to see what the officer said his or her reasons were for stopping this person, and was it a valid stop? If it wasn't a valid stop, you may have a suppression issue, which means that you could move to say that any evidence following the illegal stop could be suppressed and not used against you. Once you get into the traffic stop, though, you're going to want to look at, what led the officer to say they pulled you over for speeding. What led them to think that this is more than just a speeding stop and believe that there was reasonable suspicion to justify a search that then conducted a search that led to drugs being found. So you're going to want to see why the officer searched, and with that, you're going to want to see was there consent to search, along with the traffic stop as well. A lot of times you see canine officers used. In this kind of circumstance, you're going to see why there was a canine present. Was it with the officer that stopped you? Did they ask for your permission to do the search? Or if another officer arrived with a canine, you're going to want to see how long it took for that officer to arrive, because you can only be held for a reasonable time period. You can't be held forever waiting for an officer to come up with a canine to conduct a free air sniff. And then the last thing is you're also going to want to look at the inferences. Is dealing being charged based on the inferences around the drug possession? And are there any things you can do to challenge that? So that's really what a traffic stop would look like. And then the third situation is that you commonly see as a controlled buy. And this is where the officers are working with a confidential informant, and they set up a couple of controlled purchases. In this kind of case, the officers try to control the environment as much as possible. So they're not only relying on the confidential informant's testimony, so they do things like provide surveillance to watch them go in and out. A lot of times they'll have audio recording devices on the confidential informant, and then they even trace the money used to purchase the drugs, and then even drop the confidential informant off and pick them up. So the officers here are doing everything they can do to control the environment. But also, at the same time, if you're dealing with a controlled buy kind of case, relying on confidential informant testimony alone can be problematic. A lot of times the person may have credibility issues in their history, and you're going to want to explore that. The other thing is a lot of times the confidential informant may have an incentive to be trying to set this up, because a lot of times that they may have negotiated a situation where they're getting leniency on an offense they're facing in order for doing the controlled buy. So you're going to want to look into all of those things, and you're going to look for problems in the investigation or reliability issues with the confidential informant, so you can then attempt to challenge the credibility. So those are the three common fact patterns that you would see in a dealing case. The first is really the Terry stop, second is the traffic stop, and there's a lot to traffic stops, and the third is controlled by. So if you're facing this kind of case, this is just an overview of the things that you could think about and look at, but ultimately you're going to want to meet with an attorney to dive into these things further, to get into the really factual specifics of your situation. There's also other challenges that can be made. For instance, maybe there's issues with the scales or the weight. So you're going to look at, were the drugs weighed correctly? You also want to see if there's an enhancing circumstance alleged. Can the state prove the enhancing circumstance? And then, as in any kind of criminal case where there's an intent, can the state prove intent? For instance, maybe you were driving the car and had no awareness there were drugs or these things in the vehicle. So can the state prove that you knowingly or intentionally were dealing? So those are three other challenges you would look at. So again, thank you for watching this video. I have more videos about methamphetamine possession and methamphetamine laws and other drug cases in Indiana. So feel free to watch and call me or text me if you have any questions.